The Judiciary of the Gambia, in partnership with Pepperdine University, hosted a one-day workshop on plea bargaining at the Sadauda Kairaba Jawara International Conference Center on Monday. Plea bargaining in criminal law involves an agreement between the prosecution and the defendant, where the defendant agrees to plead guilty. This workshop is part of the Judiciary of the Gambia's preparation for the 2022 Criminal Procedure Bill, which is currently before the National Assembly for enactment. If passed, it will introduce plea bargaining into the Gambian justice system for the first time, allowing defendants to negotiate with the prosecution. If enacted, this will be the first time in the history of the Gambia's justice system accused persons or defendants would have an option to do a plea bargaining with the prosecution. In his remarks, Honorable Chief Justice Hassan B. Jallo explained the purpose of the gathering, emphasizing that plea bargaining is an internationally recognized practice in criminal justice systems.
The Sentencing Council has recommended a number of guidelines which I have promulgated, particularly in the area of sexual offenses, assaults, property offenses such as theft, etc. And these sentencing guidelines all provide some incentives to plea bargaining because they provide a reduction of sentences in the event of guilty pleas being entered by accused persons at various stages of the process, ranging from a 33% reduction in sentence to something lower, depending on the stage of the plea. So our discussions today come across this background, and we expect that the new rules which are in the draft criminal procedure code, when implemented, will carry the process much further. Guilty pleas, of course, are not new to the system. They're there. And the plea bargaining is a process, plea bargaining in criminal matters is a process which has become well established and accepted in various national jurisdictions and also even at the international tribunals. And in both systems, it has become a strategy in the criminal justice process for decongestion, for more expeditious disposal of cases in a fair and transparent manner, And we should not hesitate to use it, to resort it, in order to also attain our objectives of decongestion and expeditious disposal of cases.
Professor Danny DeWald, Vice President and Chief of Staff at Pepperdine University, discussed the university's collaboration with African countries to incorporate plea bargaining into their justice systems.
We have learned over the past couple of decades is that there is an issue across the globe that is not unique to your country or, frankly, to my country or to many of the countries across Africa, South America, India, and Southeast Asia. But we see this issue of case backlog, we see this issue of overcrowding in prisons, and we understand that both of these issues lead to a problem with access to justice for our people. In the United States, as the Solicitor General has shared with you already, this intervention of plea bargaining, or what we call in the United States early case disposition, because sometimes the word plea bargaining sounds like we're bargaining for justice, doesn't it? And people can get the wrong impression. It's also a phrase most everybody, once they learn what it truly means, that people understand. And so many in Africa have chosen to stay with the term plea bargaining, but to be sure to define it properly. We are not bargaining for justice, but that we are bringing justice efficiently and effectively so that access to justice can be had for all in our communities. What we have learned over the last 10 years of seeking to implement plea bargaining principles has been astounding. We began in Uganda, and so we have a 10-year case study of working in Uganda in every prison across the country under the leadership of the Chief Justice, in partnership with the DPP and the prisons and the police and the bar, all departments collaborating together we have seen incredible reforms made that has resulted in profound improvements on these challenges.
Solicitor General and Legal Secretary, Mr. Husseinu Tomasi, provided an overview of the history of plea bargaining and its positive impact on justice delivery.
Plea bargaining undoubtedly has a significant role in the modern criminal justice system. Plea bargaining, though now deeply embedded in the legal practices of many countries, has a history that reflects the evolution of criminal procedure, societal expectations, and practical efficiencies. The concept of plea bargaining, where a defendant agrees to plead guilty to a lesser charge in exchange for a lighter sentence or the dismissal of other charges, dates back to the 19th century in the United States. While it may seem like a contemporary innovation, plea bargaining actually developed as a response to the complexities of growing legal systems, overcrowded courts, and the need for a more streamlined process of adjudicating cases. Before plea bargaining became common, trials were far more prevalent, and the criminal justice system was focused heavily on delivering justice through a full trial process. However, as urban populations grew in the 19th century and the number of criminal cases surged, courts began to experience significant backlogs. There was an increasing demand for a more efficient means to handle these cases, and plea bargaining gradually emerged as a solution.
Commissioner Abdoulaye Sane, representing the Inspector General of Police, stressed the significance of the workshop in enhancing the country's legal processes.
The significance of this workshop cannot be overemphasized. As we stand at the threshold of an important reform in our criminal justice system, plea bargaining offers a more efficient way to resolve cases, reducing the burden on our courts while still ensuring justice is served. It allowed prosecutors and defense counsels to negotiate an agreement leading to a quicker resolution for both the victims and the defendants. This is a progressive step that will help alleviate the heavy caseloads in our justice system and enable the swift delivery of justice. I must state that this workshop is a timely opportunity for us to deepen our understanding of the plea bargaining process. As law enforcement officers, prosecutors, and legal practitioners, it is essential to appreciate how this practice will impact on our rules. Plea bargaining presents a path to achieve fairness and justice without compromising the integrity of our legal system.
If the 2022 Criminal Procedure Bill is enacted under Section 144 of the Criminal Procedure Code, a prosecutor and an accused person or their representative may negotiate and reach an agreement. This could result in the reduction of charges to a lesser offense, the withdrawal of charges, a stay of additional charges, or a promise not to proceed with potential charges. However, such a plea agreement may only be reached after the accused person has been formally charged and before the judgment is delivered. Reporting for Kerfatu, I am Landon Cisse.